Welcome everybody. My name is Professor Charles Szymanski from the University of Białystok Faculty of Law, and I'll be giving a short lecture about comparative human rights. Human rights, in a sense, they've always been with us in some ways, from old religious traditions and philosophical traditions, but in comparatively recent times they've been codified in various international instruments, telling us exactly what human rights are. The League of Nations had certain obligations about human rights, especially with minority rights. This is especially in the case of Poland and Germany. With Silesia, there was a Polish minority on the German side of the border and a German minority on the Polish side, and there were certain obligations to treat these people with respect and give them cultural and educational and language rights. And so the system of human rights we saw began with the League of Nations in certain countries, and also later progressed to the United Nations. In the United Nations era, we have various sources of human rights. We could say that jus cogens, in a sense, directly implicates human rights. It's an international law principle where states cannot derogate from certain core principles. So no genocide, no slavery, for example, no torture. States cannot make a treaty that would permit these things. And in some aspects, jus cogens could be said to have an origin in natural law, where there are some fundamental precepts about how we treat people that is intertwined with us as human beings, is connected with us simply being humans. The UN Charter itself has various provisions that talk about human rights, that they should be supported by the members, and that it should be considered in various aspects of the behavior of member states of the United Nations. It should be promoted. So it was recognized by the United Nations. The Universal Declaration on Human Rights came in the aftermath of the Second World War, and this became a little bit more, well, and a lot more specific as to what these human rights would actually include. And this has been a source that scholars and practitioners have come back to time and time again to define what human rights in fact are. And we could say that they're divided into various categories. And one category would be civil rights. Life, liberty, freedom of speech, religion, no torture, no inhuman punishment, the right to personhood. Economic rights, the right to work, to join a trade union, to receive social benefits. Also intellectual property would be an economic human right. They also categorize duties that you might have and limits on the exercise of these rights. No right to destroy freedoms in the Declaration, and so sometimes there could be a conflict. You could say maybe your right of expression exists, but it can't be used to call for genocide and to immediately kill a certain ethnic group or community. So there are duties, there are civil rights, there are economic rights. Later, after the Universal Declaration, these were codified into two main international treaties, the International Convention for Civil and Political Rights, and they talked about the civil and political rights that were in the Universal Declaration, plus the Human Rights Council for enforcement and monitoring. So there was a very light enforcement mechanism added to this. The other main human rights treaty was the International Convention on Economic, Social, and Cultural Rights. And they talked again about the economic rights that were described in the Universal Declaration. These main human rights treaties have been emphasized by different countries. And so the American approach and maybe a Western approach has been that civil and political rights perhaps are most important. Why? The American approach, for example, would be that it's essential that you give these rights to people because they would unlock any other rights that you might have. So, for example, if you have the right of free elections, the right to vote, the right of free speech, you could vote for a political party that will provide you with housing, with good incomes, with a strong economy. But to get there, you have to have a right to vote and to have a right of political discussion. So for the American approach, the first treaty would be even most important. There is a different perspective, and that would be that of China, that would say, well, these social and economic rights are actually the most important. If you don't have a job, and you don't have a house, and you don't have food, what purpose is the right to vote? So China and countries like that would have a different perspective, that we really should re-emphasize and focus more on social and economic rights. So in comparative human rights law, we do have a division of opinion on where to place our emphasis. More recently, there's been more and more detailed human rights treaties than the two that we've mentioned. They talk about specific human rights, the rights of disabled people, or persons with disabilities, we should say, and the rights of women, the right of people not to be discriminated against. And there's also regional human rights treaties. So we have, in a sense, an expansion of the law on human rights, sometimes international and sometimes regional. There are problems enforcing human rights law throughout the world. Oftentimes it's soft law, and soft law is something that is not directly enforceable. There may be a violation, but there's no effective means to get a remedy or to get a state to stop doing what it's doing. There are reporting requirements in most human rights laws. This is helpful in the sense that civic society, NGOs, could look at a country and say, you're not living up to the standards to which you agreed. And so reporting requirements can be quite helpful. There's a doctrine of humanitarian intervention held by the UN Security Council. For the most part, it should be there, that countries might be able to intervene to stop, for example, a genocide. So a severe deprivation of human rights. Maybe there could be warranted, hopefully by the Security Council, at least approving it, humanitarian intervention to stop it. And international criminal law, where there are abusers of torture and human rights, and maybe they're not prosecuted under their national legal systems, there is an international criminal court, and in a sense this also affects human rights, because it could maybe deter some bad actors from doing things that violate human rights if they know they could be prosecuted. Some key comparative issues are state versus individual, sovereignty versus international interest. Previously, international law was concerned mostly with the values and protections of the states. What space do individuals have in that? When we talk about international standards and interest, is there an international standard of human rights? And to take one example, free speech. From the United States, you could make extreme critical comments, even making fun of them, even worse, even abusive comments towards political figures. In other countries like Turkey, you could not insult the president. And other countries as well in Europe have provisions where presidents or certain authorities cannot be insulted or attacked or abused. And so we have different, human rights are applied differently in different places, and one question is, should they be? Should there be a universal standard of human rights, or should we have different human rights in different places? In Germany, it's a crime, and in Austria, to deny the Holocaust of the Jewish people. In the United States, you can do that. It's not a good idea. You shouldn't do it, but it would be protected by free speech. We have different conditions. Germany, was the epicenter of the Holocaust. The Nazi regime caused this problem. So they had different historical conditions that might justify a different interpretation of human rights. Local and regional enforcement versus international enforcement. Perhaps this might be more efficient. The European Court of Human Rights has been a leader in enforcing human rights. It's not completely soft law now. They do issue monetary penalties, and so perhaps different parts of the world could go at different speeds. Cultural relativism in human rights. Again, this is an important issue in comparative human rights. There is a freedom of religion, right? And so if I want to wear a hijab or a headscarf or cover my face because of my religion, well, under freedom of religion, that should be the case, right, in many societies. However, many European societies with different traditions have said that violates your right as a woman, that discriminates against women, being covered from head to toe in a black garment. And so we have sometimes a cultural relativism. In some countries, there's different prioritizations of different human rights, freedom of religion and the right of women not to be discriminated against. And so again, we have a comparative element where human freedom of religion might mean one thing in an Islamic country and another thing in France. I hope this was a useful overview of some of the issues that are going on in the human rights field, especially in comparative human rights. It's a very hot topic in both Europe and the United States and throughout the world, and I hope you've been able to learn some of the key principles in this subject. Thanks again for listening, and I look forward to seeing you for the next lecture in the series. Thank you.